Hi, everyone. Welcome to Talk with Tonya. I'm here today with Lauren Barros. She's an incredible attorney here in Utah, and I'm so excited to have you join us. Thank you, Lauren.
Thank you, Tonya. It's a pleasure to be here.
So, we're going to talk about your legal perspectives, and we're going to add in a little bit of the psychological aspects with that as well today. Can you tell me, why do you think that counseling is valuable in surrogacy from a legal perspective?
In Utah, the statute requires that all parties engage in counseling, and in other states, it's not necessarily required, but encouraged. The reason why I think it's so important from a legal perspective is that there are a lot of things in the contract and the surrogacy agreement that you don't want to have to try to enforce, or they might not be enforceable. And so you really want to make sure that the parties are on the same page ahead of time. So for example, termination of pregnancy. That's the biggest that comes to mind.
Yeah.
It's important ahead of time to have the parties talk about that with the counselor, ideally together, and make sure that they have similar views and go through different hypotheticals and what they would do. I think it's also important to make sure people communicate all their fears ahead of time and have them addressed. So those are some of the important legal reasons to do it.
Right. And even though it's a legal reason, it's an ethical reason and it's a human reason. We want to really make sure that people are on the same page so that this in the end will be beautiful. And the legal is what protects it from being a problem and makes sure that it's really beautiful amongst all the parties.
Mm.
Excellent, excellent. So, can you tell me about informed consent? What does that really mean, especially from your view?
It's come up recently where sometimes the surrogacy process, when it comes to an attorney, happens so quickly. And all of a sudden, perhaps I get an email and it's from a facilitator or an agency saying, you're going to be representing so-and-so. And here's the information. And you can run a conflicts check if you want. And the embryo transfer is scheduled.
Oh,
And,
wow.
and I think what happens is that people, once the ball gets rolling, you really want to move forward quickly. But informed consent, one way you can look at informed consent, one example of it from my perspective, is whether or not my client has chosen me as an attorney, whether or not they've been informed that they have a choice of attorneys and that they said, yes, I choose this attorney. Because especially when you're representing a surrogate, their fees are being paid by the intended parents, but they're supposed to have an independent attorney. And to make it truly independent, make sure that they're informed in an independent way, they should have the ability to choose who that attorney is. So that's one way that it's come up recently. Another would be, again, often with the surrogate. Does the surrogate have adequate legal representation so that she and her spouse understand all the terms of the contract that they're agreeing to? And it's important that they have an attorney who's independent, who who's familiar with the law in the state where the child will be born, so that that attorney can make sure that the surrogate really does understand all the terms of the agreement. And those agreements are so long that no one wants to go through every sentence, but it's important that the parties understand the important things.
Right. Because I bet there are times that people say, oh, I didn't realize that was in the contract, or can you tell me again what was in the contract? And
Sure.
so it makes you say, ooh, oh, were they rushed through it, or did they truly understand? Yeah. So speaking of contracts, can you tell me how a contract protects both the intended parents and the surrogates?
I can give you examples of each. So
Perfect.
the big picture is that for the intended parents, the contract ensures that at the end of the day, when the child is born, that the child will go to them, that they will have custody of the child. And that's one of the overarching goals. And for the surrogate, the big picture is that she will get paid, because that's what the transaction is really about, that she's going to carry the child, that she's going to get paid for doing so. At the end of the day, the child will go to them. But there's so many details in these contracts that are really important, and a lot of people just aren't aware until something goes wrong. So, for example, for the intended parents, the contracts typically will waive liability. So that the contract will say, if something bad were to happen to the surrogate during the surrogacy, and she were to suffer, for example, a loss of a fallopian tube, or become disabled, or to die, that the parties agree the intended parents would not be liable for her death, meaning the surrogate or the surrogate's estate couldn't come back and sue the intended parents for damages for the loss of her ability to work, or for loss of their mother, or whatever it is. In exchange, the intended parents need to be paying certain amounts of money, and they, as compensation, they also need to pay certain amounts of money for specific losses, like a loss of a fallopian tube. And they should be also paying for life insurance, ideally for disability insurance. By doing those things, their parties are saying, this is fair. We agree the intended parents can waive their liability, and in exchange, these are the remedies if I, as a surrogate, were to have a loss from the result of an invasive procedure or from a result of the pregnancy itself. If that contract's not validated, meaning it's not signed by everyone, and in Utah, it's not validated by the court, then those waivers are not in place. In Utah, the contract's only valid once the court signs an order validating it, which is the equivalent of a pre-birth order. So when the parties sign the agreement, they present it to a court with parentage documents, and then they'll get a pre-birth order where the court will say, this order is valid, if it meets the requirements of the statute. And from this point forward, the intended parents are the legal parents of the to-be-born child. Without that, there's no protection. From the surrogate's perspective, not only do she and her spouse need to make sure that they get paid, they need to make sure, for example, there's enough money in the escrow account at all times. And if the contract doesn't address it, then no one really has talked about how much money is going to remain in that escrow account to make sure that any kind of costs or any kind of agreed upon amounts are going to get paid, and get paid in a timely manner. And if she doesn't get paid and she has mounting medical bills, for example, then that could cause all kinds of problems. Another would be confidentiality. If the parties say, we want to keep our identities confidential from social media during this process, without that contract being enforceable, they can't enforce any agreement about being confidential. Continued contact after the birth. That's something that's important in the surrogacy agreement. If the parties say, we will agree that we'll continue to have contact until any one of us no longer wants it, without that contract provision, one party could continue to nag the other party for an indefinite amount of time. And then, of course, during the pregnancy itself, there's travel restrictions, there's activity and diet restrictions, there's preparations for the birth. Those are all things the intended parents will want to have set out. And for the surrogate, there's going to be understandings about how much she'll get paid for lost wages, how much her companion would get paid for lost wages, what would happen if she were to be unable to make medical decisions, what she would want parties to do in that case. So they're all kinds of important things.
So the contract is the most important document to protect everyone.
For sure.
Yeah. For sure. And you go through it line by line with either the intended parent or the surrogate, whichever one you represent.
That's right.
Absolutely. That's great. Can you think of some common legal risks that you think people overlook or they're shocked that is in the contract?
I think the most common legal risk that seems to shock people is that the contract itself is not enforceable until it's validated by the court. Often, by the time people come to me, they've already completed the contract and done the embryo transfer, but it hasn't been validated by the court.
Oh.
So when they learn that the contract's not enforceable at that point, it's disturbing to them.
Yeah.
But I guess a shocking provision that would be in the contract that people might not expect could be, sometimes people say, hey, I play a certain sport. That's part of who I am. And the contract might say, we don't want you to play that sport during this entire pregnancy. And they might say, well, I was able to do it with the approval of my doctor for my previous pregnancies, and it's healthy, and there's no reason I shouldn't be able to continue. The intended parents might feel differently. Sometimes I feel like that and the travel restrictions are often what I think surprise surrogates sometimes when they say, hey, I have a family reunion planned. It's only a few months into my pregnancy. It's in France or it's in, on the East Coast or something. And sometimes the intended parents really don't want to risk having something happen to the surrogate out of state. For surrogates, I think sometimes it's surprising that they have to share all of their medical information. Really everything is relevant to the pregnancy. For intended parents, I think sometimes they're surprised at the detail and of all the things that they could have to pay for. And, often at that point, they've spent so much money already, and I think that's difficult for them too. Also in Utah, this isn't really part of the contract, but to get the contract validated by the court, the statute says the intended parents have to have a home study. I always file a motion to waive the home study, but instead of the home study, I give the court what they would get from a home study, but provided by the intended parents to make it easier and cheaper and faster for the intended parents. But that does mean the intended parents will need to get a criminal background check if they don't already have one, a state child abuse check, and then write a profile about themselves, their thoughts on discipline, their childhood, all these sorts of things. And I think that usually makes intended parents feel frustrated. In other words, often there's a genetic connection and it's their own child, and they think, why should I have to go through all of this? But it's a hurdle that we have to jump through.
Right. And I think overall, even though there are a few hurdles in Utah, it's one of the states in the US that is quite safe for surrogacy from a legal perspective.
It's the only state I've practiced in, but I think it's great because every couple of years, a legislator might propose to change the surrogacy statute. Every couple of years, legislators propose to change all of our laws. But when it comes to surrogacy statutes, if they say, hey, we think maybe surrogacy isn't safe or it's not a great idea, then we can have a hearing at the legislature and we can come and explain why the statute is so safe and protects all the parties. For the surrogate, they know that the intended parents have passed a criminal background check. They can feel comfortable with them. They know counseling is required. They know the compensation has to be reasonable. For the intended parents, they know that there's a statutory process to get that order from the court, both the pre-birth order and the post-birth order of birth. Other states don't have a statutory process necessarily. And so it might depend on the judge, for example. In Utah, it's their rules. And as long as they're followed, then there's some certainty.
Yeah, I hear a lot from intended parents that they're very nervous that the surrogate may want to keep the baby. And in Utah, that really isn't a possibility because if they validated their contract through the court, it's very clear to everyone what's happening, right?
That's right. Exactly.
And in other states, it may not be as strict that way.
Exactly. Yeah.
So, kind of talking about the differences in different states, can you give just like a blanket understanding of some ideas of how other states do it?
That's yes and no. So
Okay.
yes, I can tell you that every state is different. Many states have statutes, many states don't. But no, in that it's important to know your limits. And I know that I understand Utah law and I understand commonly accepted ethical guidelines from ASRM and from my organization, the American Academy of Adoption and Assisted Reproduction Attorneys. But I don't know the specifics of any other state. And for that reason, anytime, and this is most of my cases, anytime one of the parties lives out of state, one of the parties lives in Utah, we make sure that we have an attorney from each state who can at least advise during the contract negotiation process.
Very good. So then everyone is properly protected and
Right.
they know that the state that they're going to is safe and that the situation is set up correctly so that everybody gets what they're looking for here.
Exactly. Yeah.
Excellent, excellent. So, is there additional complexities when somebody comes internationally when it comes to the legal aspects of everything?
Definitely. So, it depends on the country. Some are, I say, there's a range of 1 to 10 of how much harder it is, depending on where the intended parents reside. Sometimes, and actually sometimes people reside within the United States, but they might have a dual citizenship with another country, and they want to be able to preserve the ability for their child to also have that dual citizenship. So as soon as I meet with intended parents and learn that either they reside somewhere else or they might want to be able to get parentage recognized in another country, then I encourage them strongly to meet with an attorney from that country and find out what specific things we might need to do on the front end to make it easier down the road. And the sooner they contact an attorney from that country, the sooner I can talk with that attorney and make sure that the way I draft the court order helps facilitate that process. So, for example, in England, and I hesitate to even say what the law is in other countries because it's constantly evolving. But in England, surrogacy is allowed, parentage is recognized, but really specific things have to happen, and the court order has to say certain things. In Italy, surrogacy is not recognized and it's a crime. And so you can still be Italian and engage in surrogacy outside of the country, but there's very specific things you have to do. And it's really important to know them ahead of time.
So
And then finally, I want to make sure that if people do live outside the country, that they have all the documents they need to come to Utah and pick up their baby when the time comes.
Right, absolutely. They need to be able to get their baby home and they need to be able to get here in order to do that.
Right, right.
And I'm assuming that you know a lot, or at least some international attorneys. I know some international attorneys. We know people who know attorneys, so we can help guide. Because, please correct me if I'm wrong, you don't want an attorney in the country. You want an attorney that works with third-party reproduction in the country.
That's a distinction. Mm-hmm. For sure.
Perfect. Excellent. Do you, in this whole process of working with international families, domestic families, surrogates, or intended parents, do you collaborate with other clinicians, other attorneys a lot during this process? And how does that work?
I really do. I probably collaborate with, I don't have much interaction with the clinics. but I have a lot of interaction with the agency, if there's an agency involved, and a lot of interaction with the facilitator. I might have interaction with counselors, always with the attorney representing the other parties, plenty of interaction. So, for example, with the agency, sometimes people come to me without an agency and they aren't using an agency. So that's not an issue, but most of the time they do have an agency. And so I'll make sure that I have the right contact person and bring them into conversation so that they can help gather all the documents we might need. And they can help make things easier and less expensive for the intended parents from the get-go. And if there's a dispute after the agreement signed, maybe during the pregnancy, the agency can serve a crucial role in helping the parties to talk through that and navigate any kind of misunderstandings or communication lapses. And then with attorneys from the other side, when I say the other side, representing the parties, if we have any kind of disagreement about the contract, I really like to just call them and talk with them about it and kind of talk it through, and then come up with something that's going to work for everyone, because we really want to all be on the same side at the end of the day for it to be a successful endeavor. So that's attorneys, that's clinicians, the counseling. Sometimes people they may have had a psychological evaluation, but they haven't actually had counseling about surrogacy. And so it's nice to be able to have resources to refer and say, hey, you can do Zoom counseling with these providers. They're licensed to do it over Zoom in your state. And then, I do end up talking with healthcare providers, with fertility doctors every now and then when it comes to things like legislative changes. And I think that may have been how I originally met you, Tonya.
It is.
When the legislature at one point was going to mess with the law, and we got together, a lot of us who worked in this area and assisted reproduction, and said, let's have a meeting and figure out how we can attack this.
Yeah, it was wonderful. Everybody banding together to really help educate and guide those legislatures on what it was, why it's important, and who we're affecting, and that it's a beautiful thing. Yeah, that's right. Definitely how we first met. It was so nice. Yeah.
And I feel like I continue to learn from these contacts. So when you and I get together, I always learn so much about things that have evolved since we last talked. Maybe medical procedures. And the same thing with friends of mine who are reproductive doctors. The last conference I went to that discussed this particular procedure was maybe 2 years ago, and things have completely changed since then.
Yeah. Reproductive medicine is a really rapidly evolving part of medicine. I've been doing it for 18 years and it doesn't look anything like it did when I first started. We transferred 3 to 5 embryos because we couldn't grow embryos out to a blastocyst stage, and we couldn't tell which ones were chromosomally normal, and we didn't know, we couldn't even freeze embryos at a blastocyst stage. We could only freeze them at a day 3 stage. So it has changed incredibly, and 18 years is not a very long time to see so many huge changes in this medicine. So Lauren, I'd love to hear your opinion of some of the ethical safeguards that are put in place for surrogacy. Which ones do you see are very important in the process?
There's so many. At the last conference I went to this spring, a bunch of us were talking about how we now, even for sperm donation agreements, want to make sure that everyone has an attorney. So of course for surrogacy, everyone needs to have an attorney, but even for sperm donation, we think it's really important that everyone have that informed consent, including the sperm donor, if it's a known donor. We also talked about with the known donor that we include in the contract information about the donor sibling registry, and or limiting how many donations the sperm donor makes, because this wasn't really discussed in the past. And people are starting to say, hey, this could be an issue. We don't want our child to have hundreds of siblings, and let's talk about it. And let's see if we can reach an agreement. Moving on to embryo donation, there's so many issues there too. So for example, what happens to the embryos if the recipients only use some of them? Are they going to return them or redonate them back to the original donors? Or do the original donors have say over what they do with those embryos if they're not used in the future? Those sorts of things. And then surrogacy, I feel like it's really in the media. Maybe it's just because I pay attention to it, but there's a lot of negative media coverage right now of surrogacy. And it's a shame because I help so many people and I don't have negative experiences. I'd say maybe 1 out of 100 people have problems after they've entered the agreement and they're started on their way. So we keep adding more ethical requirements for attorneys in the Academy of Adoption Assisted Reproduction Attorneys. Now we are requiring that as attorneys, we make sure that we physically see our clients, for example, so that they are who they say they are, that they have not committed any crimes in the past, and we either meet by Zoom or in person. We want to make sure that everyone feels like it's a fair process at the end of the day. That's been the big overlay. And so that's part of informed consent. That's part of everyone understanding the contract and having the ability to negotiate that contract. Some people feel as though surrogacy itself is not ethical, and I think those are important discussions to have. But I don't agree with that, obviously.
Obviously.
Yeah.
You've helped thousands of families to do it because you feel like it's a beautiful process and you spend so much time protecting them from those problems.
And so many people, it's just, I think for almost everyone I help, it's the only way they can have children.
Yeah.
They're genetically related to them. And it's easy to criticize it if you don't need it yourself, if you're not in their shoes.
Yeah. And as long as we're all, as a team, the agencies, the clinics, the attorneys, the psychological companies are all teaming up together to make sure that we're all watching and we're all protecting and all doing our best to take care of everyone, then it really is a beautiful process. I go to bed every night going, wow, what a beautiful thing we've done today.
Oh, that's great. And it's true. It really is true. And I think it's important as an attorney to represent both intended parents sometimes and surrogates and their spouses other times, because that way you really feel you understand what it's like to be in all of their shoes. And I think that almost every surrogate I work with wants to do this to do something good for someone. They want to bring life to someone else's family. They just want to help. And of course it's important that they receive compensation too, but they're doing it to try to make the world a better place.
They're not being taken advantage of. They're actually making this choice to do something beautiful.
Right. Yeah.
Incredible. Has it ever happened to you in all of the years you've done this where you had a psychological concern about an intended parent or a surrogate? Or what would you do if you saw that? How did you or would you handle something where you thought, this feels funny to me?
It depends where in the process we are.
Sure.
So if the surrogate's already pregnant, they come to me, which happens often, then I want to make sure that the intended parents have good counseling and support, that they're using that counseling and support. If they're early in the process, when you brought this up just now, the first situation I thought of was years ago in Utah, you do, as an intended parent, have to provide a criminal background check. And a client had a criminal background check that showed that she was charged with a crime for some behavior that we would call as kind of crazy. And when I spoke with her about it, she explained that she had a mental health condition and that several years ago it was not treated. Now she treats it appropriately and there's no concern. And we discussed it. And I said, okay, well, I think that's going to be fine. And that background check showed up as an attachment to the court pleadings, and the judge asked to have a hearing. And at the hearing, the judge wanted to know about this. And, she explained it. And I had her explain it to the judge the way she explained it to me. And the judge said, that makes a lot of sense. And I'm glad that you were able to tell me about that. That's probably the last time I've had a hearing with a judge. Usually it's much quicker process, but I'd say once a year someone has charges on their criminal background check that cause the judge maybe some kind of concern. I think most people I know who are going through this process are receiving mental health treatment. And they are or have received mental health treatment because it's a very stressful time of life and a very stressful process. And most of them are appropriately getting good help and counseling.
Yeah, that makes sense. When I was working in the clinic, I always thought, which came first? It's so stressful and so difficult to get pregnant through this process or any fertility process that so many people have anxiety and depression, and it is so overwhelming for them. But once you see them on the other side of it and they have that baby in their arms, it's so healing and so beautiful. So difficult times in all of our lives, we need some help, some counseling, some people, some medications and things to get you to that next step.
Definitely. And I remember going to a panel discussion about this where it was for parents who'd had a child through surrogacy, and they said that their struggle actually came afterwards, after the pregnancy and delivery, because they thought that once the child was born, everything would be great. And they had built this up in their minds for so many years, and then the child was born. And babies are hard. Maybe not for everyone. For me, certainly it was very hard. And you're getting no sleep, and they were suffering from a very normal sort of environmental depression, and they felt guilty, and shameful that they were not just overjoyed all the time after looking forward to this moment for so long. And the panel was talking about how this is very normal and also just not talked about. People don't talk about how there might be times when you're depressed even after you finally get the baby you've longed for so long. And so that's also a very good time for mental health counseling, and even group counseling, just to kind of say, hey, we're all going through this.
It is so true. It's postpartum depression when you deliver a baby, and they attribute so much of that to hormones, and certainly hormones matter, but so much of it is the reality that, wow, having a baby is a beautiful, incredible thing. However, it's exhausting and it's hard, and there are some days you're like, how do I give this back? I don't want to do this anymore. Right? But you love them so completely, you never could.
I remember when I gave birth, my OBGYN said to me, and it was challenging to get pregnant. And then I finally did, and I gave birth, and my OBGYN, I remember coming into the hospital room and saying, well, enjoy that baby. And I remember thinking about it like a week later, thinking, he's never had a child. Does he know what it's like? I've I'm exhausted. And she keeps crying all the time. I Now I often, when clients have babies, I almost say, enjoy your baby. And I think, nope, that might not be the right thing to say. It'll come with something else, but it's a hard time after that happens. And back then, we really didn't talk about it, but I feel like luckily now it's really talked about so much more, and counseling is really encouraged so much more.
Absolutely. Yeah. I try to give my intended parents a little heads up that it's okay to feel overwhelmed. And you're going to get through just like all of the other moms and dads do.
Right.
But there's moments that's going to be tough. So, talking about everything that we've talked about, I think that one of the most important things that I hear you saying about Utah is on the legal front, validate your contract before you get pregnant. Go
Exactly.
through the court process to make sure that contract is enforceable so you don't have that, oh my gosh, wow moment that I have been doing this without any kind of protection for anyone. So am I hearing that right?
Yes. Yes.
Perfect. Excellent. And then what other advice would you give a person who is just getting started in this process?
There's so much. I would say that they should seek out someone like you
Thank
who
you.
can help them find the right people in the right situation, and they should try to talk to other people who have gone through the same thing, and get as much information as they can directly by talking with people at a time.
Yeah, Google isn't very reliable when it comes to trying to learn things. It's reliable for how to grow your grass and how to paint a wall, but unfortunately, surrogacy is so complex. You need somebody who's actually in the industry. They need to talk to you as an attorney so that you can explain, and they can understand the legal aspects. Talk to somebody like me or somebody else in the industry that understands the steps and the clinical portion of it, making sure they're guided correctly. I always tell people, choose one person that you trust. And whoever that person it is, whether it's you or me or their doctor or whoever it is, follow that person's lead, because that person won't lead you astray. Because everybody who you're working with that person you trust will be someone they trust as well.
It's a really good piece of advice.
Thank you. All right. Well, thank you so much, Lauren.
Pleasure, Tonya.
I know we'll be talking again soon.
I look forward to it.